I don't know. After hearing him calm and talking about the tether story, it's probable.
Go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
What's going on? This is Colin. How's everybody doing? Happy Wednesday night. Hope everyone's doing well. Hello to everyone in the chat. I see a lot of regular names walking through here. Phil, Bob, Jedi, Michelle. I saw Sushina, Jen, everybody. James is here. Everyone's here. Thank you so much for coming to hang out. I've got a good video. Got a lot of the judge's patience today. Got one in. Let's see. I got Judge Simpson. I've got a Judge Boyd. I haven't used Judge Boyd in a while. And let's see. I don't remember the last one we finished with. We'll find out together. All right. Before I hit this play button, you already know what to do. Hit that like and subscribe. Do your jump kick back flips. Let's go. What's up, Mike? Hey, Christy. What's up, Johnny?
This is the prosecuting attorney Morgan Barossa on behalf of the people.
Good morning, Assistant Public Defender Warren Parenting on behalf of Mr. Bloom. Mr. Bloom, can you state your name for the record?
Excuse me, Your Honor.
Yes, ma'am.
My name is Jeffrey Bloom, and I have asked to disqualify the Public Defender's Office. I was referred for a competency exam when I did so, and didn't receive the competency exam, but I made this part of record on November 1st. I have contacted the Public Defender's Office multiple times, Your Honor, and no one will accept my call because they're saying they don't handle my case. So 2 weeks after I visited you.
Hold on 1 second, Mr. I'll hear from you, but just hold on a second.
Yes, sir.
Who has your other matter? That
It's Sam Bernstein, but I would like to represent myself in this case, Your Honor.
Okay.
Thank you.
Okay. Well, hold on. I'll hear from everybody, but were you done, Mr. Bloom, with what you were saying?
Well,
in that?
Yeah, go ahead.
Okay. What is yours?
I'm just going to echo what Mr. Bloom was saying. We are in the process of withdrawing from this case due to a breakdown attorney-client in the attorney-client relationship. I'm not sure why the paperwork and all that didn't get to the court yet. I believe it should have been handled before today, Your Honor. It might also been an issue. We don't have the competency report. Our office, or the MAC office, may be waiting to receive that before we withdraw.
Okay.
But we are in the process of withdrawing, Mr. Bloom, correct?
May I speak again, Your Honor?
Okay, hold on just 1 second.
Before he talks so much where I can't get a word in. Yes, this was today. I do have the Q video that's up next. Guys, like spoiling the surprises. It's not the only surprise though, but Q is here. And he's in the next case. And yes, the Judge Bryant clip is the last clip on this video. I was acting like I didn't know what it was, so surprise. Heineken, Heather.
I'm just looking, Mr.
Yes,
Bloom, to
sir.
see what I have. Okay, go ahead.
I was referred for a competency exam because I fired the Public Defender's Office. Judge Slay, in my multiple felony count case, says there's no reason for me to take a competency exam. Okay, anyway, Your Honor, I have called these people for week after week. 2 weeks, like I said, 2 weeks after our last visit. Every time I call them, I ask for discovery. I ask for the police reports. I ask for witness statements, hospital reports, everything. I am denied, and they hang up on me. These people are highly incompetent.
Okay, so, well.
Cease and desist.
Hold on one moment.
Immediately. I am
Just
denied law library.
Okay, I'll hear you. I'm just trying to sort out what you're telling me.
I'm just a little
Because they're-
frustrated.
I got you. So the problem is that on the other case, the felony case, the PD did withdraw on, and that's where you have Mr. Bernstein now?
And I was threatened with a competency exam that time also, Your Honor.
Okay, I don't know anything about
Yes,
that.
sir.
I'm
Yes,
just
sir.
saying,
Yes, sir. You're absolutely correct.
I'm just trying to figure out representation.
Yes, Your Honor.
It's Mr. Bernstein. Okay, so that's who's representing you in that matter right now.
Yes, sir.
Okay, so it seems to me, although you want to represent yourself,
sir.
that can happen But it seems to me that, I guess I'm unclear as to why. I mean, I don't know what the withdrawal was on the other thing, but it doesn't matter. If there was going to be a withdrawal, then at minimum, Mr. Bernstein could be appointed to represent Mr. Bloom in this matter, and then Mr. Bloom can make a decision as to how he wants to proceed with it. But, and I'm just unclear as to why that hasn't happened, but that may not be you, Mr. Bloom. Turn around, face me, okay?
I'm curious.
I'm not, well, but Ms. Perroni may not know.
Well,
Okay, so don't stare at her.
None of them seem to know.
Well, that's okay. I don't know, you don't know, nobody knows. I'm
Nobody.
just saying what should have happened. So however this occurs, this has got to be straightened out. So I don't, you're held on the other matter at this point, right?
Yes, Your Honor.
Okay.
With
so-
no bond. Might I
Okay,
add.
all right. That's the one that's before Judge Slay.
Yes, Your Honor.
Okay. I just want to make sure there's not going to be a delay that keeps
Oh, there
you
will be.
incarcerated. Well, that
That's,
keeps you.
that's why this case was brought up. You'll see the light. You will see the light, Your Honor.
Okay, so, I just want to make sure that you weren't going to be held if I adjourn this matter out to get all this stuff straightened.
Well, I just want, this is the only thing I'm wishing. Do not allow these people to deny me a law library, Your Honor. Please, I have been denied law library for 15 months.
All right, for kind of how I don't know how to word what I want to say about this guy, about Mr. Bloom. He seems a little disruptive, but he's polite at the same time. He just makes a lot of demands, and I can see why no attorney wants to work with him. But yeah, he's been like this. He's been around for a while, and this is from today. I think that was Lane that asked. This is from today. Hey, what's up, Lolly?
You mean at the jail?
Yes, yes, Your Honor. And I know they try to say that it's policy that you have to have representation of yourself to have law library. That's a blatant civil violation.
All right.
Also,
Go ahead.
if you could just allow me to have law library, if you could demand those people to stop denying my due process and my rights to the courts, I would highly appreciate it. And if you think I need a competency exam, you can send me for a competency exam, but please stop denying my law library.
Well, I'm not, this is set right now for a competency hearing, but you haven't been interviewed.
Oh, no, no, this is blatantly done for a reason. I'm
Okay,
well
all right.
aware of it.
Okay, all right. We'll get to all of that eventually, Mr. Bloom, all right?
I think he's about the same as
Um,
Jeremy. Oops, sorry. Meant to pause it and I did the whole pause play. I think he's about the exact same as Jeremy Shue. Except he's not really yelling. He is demanding things, so that's not good. But he thinks he knows what his rights are. They may or may not be right. Judge Simpson handles it, though.
Thank you for being patient with me, sir. I do have Parkinson's, so if I make jerky movements, or I think I made the court aware of that last.
Yes, you did, and you're welcome. Sometimes patience is all I have. Sometimes it may, but here's what I'll do. Let's put this out to the 7th. I don't.
I have court with Judge Slay on the 8th.
Hold on. I just want to make sure. So I think this is going to be another issue. I just want to make sure. Okay. So, oh no, I do. Okay. So I have an order for competency that was signed in this case, but that probably paired along with the other.
There is no competency in the other case.
Hold on, just stop for a moment. But now what you're telling me is that there is no competency ordered in the circuit court case.
There never was.
Okay.
I'm fully capable, Your Honor.
I think if you haven't been interviewed for competency
No.
yet, then here's what I'm gonna suggest we do, Mr. Bloom. Let me adjourn this out, get it straight, let them get. If you have Mr. Bernstein, hopefully that's what they'll do. Just put Mr. Bernstein temporarily even on this case. Okay.
I want my-
Just hear me out,
They're
okay?
gonna deny me law library.
But Mr. Bloom, hear me, but hold on, just hear me out. To get rid of the competency order that's in my file.
Okay,
That's what you follow me?
I got you.
So if the MAC office, I can't direct them to do it. If they put Mr. Bernstein on that case, there's no competency in the other matter, try to get rid of the competency in this one. And then if you want to represent yourself, then I can entertain that motion.
Can you stop the denial of the due process? Please.
That's not, I'd have to have a full-blown hearing on it, Mr. Bloom, and I'm not going to do that.
Oh.
Because I'm not going to do that only because right now, if their policy is, we may be able to get you there,
It's an illegal policy.
Mr. Bloom.
I don't mean to be a problem, Your Honor.
No, you do.
But one thing, one
Mr.
other
Bloom,
thing-
how can we start out, no, just listen, how can we start out so well? And then I
Is
hear
that
you,
being
no,
just-
just listen. And then, no, just listen to me. We start out so well. And then I try to get you to where you kind of want to be. And then you fight with me about it. And then you just go at me again. I don't know why you do that to me.
Because there's multiple issues.
Okay,
here.
I know. I hear them all. I'm used to sorting out issues. Mr. Bloom.
Yes, Your Honor.
So here's what we're gonna do. All right. What we're gonna do, I'm gonna adjourn this out to the 7th. Let that one part get, here's what my hope is. That the one part regarding the attorneys get done. Get the competency off of this case. Then I will entertain your motion to represent yourself. If I grant that motion, then my understanding, based upon what you told me, if you're representing yourself in a case, then you're gonna get your law library privileges.
There's
So I'm
still-
trying to
All right, thank
get you there.
In the meantime,
Oh, boy.
one other thing, Your Honor.
Oh, another thing,
One thing.
really?
I've asked the Public Defender's Office for the discovery in this case, the police report, the victim's statements, the hospital statements, the officer's statements that said I assaulted this medical staff in the jail. Well, they've denied me those on multiple occasions and they keep hanging up on me when I call them. They say, we don't represent you. So I have this for the clerk of the court.
Mr. Bloom, stop right there. Miss Perrone, do you guys have discovery on this case?
Yes, we do.
Can we then do this? Can we try to get Mr. Bloom a copy of that prior to the whole thing being done?
Yeah, legal fiction. He's been in court so long, I don't even remember what his charges are. I don't think they even talk about him. This is all about giving him access to the library. And why don't they give him access to the law library? Like, I don't. Is that weird of a request? I mean, even if he's not pro se, why is that I mean, I don't know. I don't know. Who knows? I don't know how it works.
Okay,
Yeah, we can get it to the jail today.
okay, very good.
Full. Because the report that I got from the officer says that all the statements were included, but they weren't.
Okay.
Can I give you this, Your Honor?
I don't know what that is.
It's for discovery.
What is it?
It's the same thing one of your esteemed attorneys would write for discovery. It's asking the clerk of the court to grant me the discovery
I already have the discovery request in, and I'm trying to,
from them, but I'm not getting it.
okay, what, did you hear what I just said to them?
Yes, Your Honor.
They're gonna get that to you. They're gonna try today. Mr. Bloom, if it's tomorrow, don't come screaming, all right? They're gonna get
No.
it, they're gonna,
I've waited since October 17th. Excuse me, Your Honor. I apologize. I'm really
No,
frustrated.
no, you don't. I know you apologize. I know you don't mean to be this way, but you are.
I am.
And I'm trying to just solve your problem. So if you had listened, what you told me you didn't have discovery. I looked at them, I said, do you have it? They said, yes. They said they'd try to get it to you today. I can't deal with what happened in the past.
But they
I
said
can't,
that.
okay, I know, Mr. Bloom, Mr. Bloom.
It's all good.
I can only
So
solve
what
the
if they
problem
don't-
that's in front of me.
So I write a grievance on them then, right? I write a.
Well, I
Bar
don't know that you
association?
want to do that. All I want is you to get the discovery. If you're telling me that's your problem, then I'm trying to solve your problem.
All right, thank you. Appreciate it.
I almost hate to ask this, but there's nothing else, is there?
Well.
No, good. Mr.
There
Bloom?
is one more thing, Your Honor.
Oh.
I'm being denied of dental because I do not believe in taking injections in my mouth. And they're telling me that for that reason alone, they are denying me an extraction of an infected tooth. And if you will look at your video from 11/12 of 2022, you will see my face was swollen like a pumpkin and I was clearly sick with an infection. This is happening again.
Okay, Mr. Bloom, let me stop you.
I just put it on
With
record.
regard, okay, you
Thank
put
you.
it on record. I
Thank you.
don't get involved in medical decisions
Well,
made at the jail.
That's part of your
All right.
job too. But
All right.
have a good day.
Thank you. Bond will continue. No. Could have been a whole lot up there. Just wasn't. Court calls the case of the.
I love how long it took him. He had to compose himself for a good 10, 15 seconds before he could even call the next case. He's just like, man, yeah, that was a fun one. Michelle, I did not nail down a time with him yet, and I don't really want to spread that news around yet until it's confirmed. So I know there are people that know because they were in the chat, but yeah, let's. Anyways, back to Judge Simpson. This one's a happier one. This is the only one that's not judges holding in their tongue, because we got McDuffie back
Is it
in front of Judge
Abday?
Simpson. Also,
Abdi?
Q.
I messed that all up.
Good afternoon, Your Honor. APA Rachel McDuffie on behalf of the people.
Wow. Wow.
I promised you that when I went to Court TV, I was going to come back to haunt you.
Yes. And this is very haunting. Miss McDuffie, how are you?
I am good. How are you, Judge?
I'm doing very well. Thank you. Is the defendant present? They're here. Abday.
Debbie Baker. She's on Zoom, and one of the best parts about Zoom is you can log in wherever you want. So that's how she's there right now. She's not actually in the courthouse. Zoom technology. I can't wait to hear your response for that.
Is it Agbai? Say that. Oh, okay, they're on.
Hello?
Hello, do you have a camera?
Yes, I can turn it on. Just 1 minute. I'm trying to figure it out. I've been on the
Okay.
for a minute. Sorry about that, Your Honor. Just one.
No,
It's not
it's
letting
okay.
me start my video.
It's not letting you start your video. Okay.
Okay. It's letting me
Oh,
it's letting me activate my camera. Just
oh, no, we got you. Yep, you just took that thing off your head. Okay.
oh my goodness. It's embarrassing. That's my bonnet. Sorry about that, Your Honor.
No judgment. Don't worry about it. All right.
Big mess.
Okay, state your name, please.
Senna Jang.
All right. All right, sir, you are before the court on a misdemeanor complaint. that alleges that on the date of July 28, 2023, at the location of 2201 Hogback Road, that being the Washington County Jail, that you did, being a person to whom a sober link had been delivered, did embezzle or fraudulently convert that to your own use. And that belonged to Judicial Services Group. That is commonly known as larceny by conversion, $200 or more, but less than $1,000. Do you understand the nature of what you're charged with? I'm not asking you whether you did it, just do you understand what you're charged with?
I understand, Your Honor.
That is a misdemeanor. It's punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property taken or converted. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
I do, Your Honor.
All right. The first question I have for you is, do you want to be represented by an attorney?
No, I don't have an attorney present.
Pardon?
I do not have an attorney present, Your Honor. No, I don't need
Right.
to be represented.
My question is do you want to be represented by one?
No, I don't think that's necessary for this case.
Are you sure?
Yes, in this situation, I think it's a misunderstanding. So, no, I think okay.
Well, sometimes misunderstandings can lead to very bad results. There's probably
yeah, my attorney is Andrew
probably,
Bonner.
there's probably 365 reasons why you might want an attorney.
Sure, yeah. Assign me an attorney. My attorney.
Yes, okay, let's do that.
Defendant.
All right, this is a public
Sure,
defender
thank you, Your
case.
Honor.
You're welcome.
Debbie, thank you so much. I appreciate it. And welcome to all the new members. That is very generous. Thank you so much. Also, since we're paused, it's Q. Waiting for Heineken to just start spilling off. But yeah, he's back.
Thank you and good afternoon, Your Honor. Assistant Public Defender Counsel Gomesi on behalf of Sina J. Agbai. Your Honor, at this time, we would waive formal readings and stand mute to any charges.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea on his behalf. I will adjourn this matter to Ms. McDuffie. You're going to have to be handling this here on out.
I don't know the answer to that question. I'll have to.
Okay, well, somebody's going to have to handle it.
Yeah.
And I'll just I'll just adjourn it to the 7th and let the prosecutor's office figure it out. February 7th, 2024, 9 a.m. I will set the defendant's bond at a $5,000 personal recognizance bond, standard conditions, including no assaultive behavior or possession of weapons. I will also indicate that there's to be no use of alcohol, recreational marijuana, or any illegal drugs.
And
All
I
right.
just want to clarify one thing, Your Honor. It's my understanding that when this was, at least when this was authorized, the defendant resided in the state of Colorado.
I have him in Ipsy. Are you in Colorado, sir, or in Ipsy?
Colorado, Your Honor. Yeah, I'm permitted to take care of the state of Colorado.
Okay, so you're in Colorado at this point.
Yes, sir.
All right. Yes, I guess he is.
Okay.
All right.
Then I need you to call the Public Defender's Office and leave updated contact information if possible. Do you have that phone number?
Sir, let me give you the public defender's phone number, okay?
And I think I cut it off right here.
Yeah, sure. I'm ready.
All right. It's
Yeah, we don't need the public defender's phone number. It's not like it's going to hurt anybody, but I don't want it out there. All right. 2 Judge Simpson cases done. I think this is the case where we had to, is it Boyd next? I think it's Boyd. Let's go. This one's fun. This was fun. We get called out in this one. Not me, not my channel, but yeah. As a community, we get called out. If it's Judge Boyd. Is it Judge Boyd? Nope. I'm so great at that. putting you guys on this like, oh, what's gonna happen, and then it's a completely different clip. This is a potential subset that's just kind of funny. This one's quick, and then we go to Judge Boyd.
Lord, if you will.
What's your name? Your system, and you're all set, okay?
Thank you very much, everyone.
You're welcome. Thank you. All right, have a good day. All right, you're welcome. Damon Williams.
Lord, if you will.
What's your name?
Lord Damon.
Okay, so I'm looking for Damon Williams. Damon Williams, going once?
Yes.
All right, is your name Damon Williams, sir?
Yes, Lord Damon. It's Damon.
Damon, is it Damon Charles Williams?
Yes, Lord.
Okay, all right. Now calling the matter of the people versus Damon Charles Williams. This is ticket SP 1486498, count 1, 6 to 10 miles over posted speed. I also have ticket SP 1486811, count 1, drove with revoked license, count 2, drove without cycle endorsement, no moped license, either one. Appearances for the record, starting with counsel, please, first.
Good morning, Your Honor. Alexandra Miller, P86290, on behalf of Mr. Damon Williams, who is present via Zoom. Mr. Williams, please state your full name for the record.
Lord Damon.
Sir, that's not your name for the record on the tickets. You have to state the name on the record for the tickets. Then you can state what name you would like me to use, and I'll use it, okay?
Lord Damon will suit. Fine. Thank you.
All right, one more time. Damon Charles Williams, is he present? Damon Charles Williams, is he present? Damon Charles Williams, is he present? It's now 9:44 a.m. No response being had for that person. I'm going to put these matters into show cause. Attorney Miller, if you get in contact with your client, please let them know. I'm going to have the show cause date looks like it's February 14th. But if you get in contact with him before then, I'm more than happy to put this matter on the docket. Last call, Damon Williams.
Yes.
Okay, sir. I know what you may want me to call you, but for these tickets, I'll call you. You have to answer to that name, and then I can call you what you want to be called, Lord Damon Williams.
Lord Damon is fine.
Lord Damon, okay. But these tickets, are you Damon Williams as well, sir?
I am.
Okay. Okay. All right. Attorney Miller, have you had the opportunity to speak with your client? How do we want to move forward with these matters?
I have had the opportunity to speak with my client as well as Ms. Mason for the people. Ms. Mason did tender an offer. I tendered that offer to my client. He wishes to reject that offer at this time and set this matter for jury trial.
Okay. All right. If that is the case, we're looking at, check your calendar for March 18th and let me know what it looks like, Attorney Miller.
March 18th does work for me, Your Honor.
Okay, my jury trials are in person. Mr. Williams or Lord Damon, this matter will be in person at 36 District Court. That's 337. Our jury trials start at 9:30 a.m. on that day. The Friday before, though, I need you all to come online for what's called final pretrial. I just want to make sure we're going forward with this matter before we call in jurors. So online at 10 a.m., we'll have a final pretrial.
That was 10 a.m.
Yep, at March 15th at 10 a.m., just to make sure we're still moving forward, to make sure we have jury instructions together, and then we'll have the in-person. I think he's looking for a pen to write it down, so when he gets back, I'll give him the information again, because he was looking all around trying to find a pen. Okay. All right, I'm gonna say the date again, sir. So we're gonna have a final pretrial on March 15th. That's online at 10 a.m. That's just to make sure we're moving forward. March 15th, 10 a.m. online. The jury trial will take place March 18th at 36th District Court at 9:30 a.m. Okay? His bond will continue at $0. Okay?
All right. Thank you very
And we'll
much, Your
see
Honor. I
everybody
appreciate
for that
you.
final pretrial. Okay?
All right. Thank you very much. I appreciate you and your staff. Have a great day.
You're very welcome. All right, sir. Make sure you come down in person, but make sure you sign online that Friday before the trial, please. Okay?
Very well.
Thank you so much, sir. Okay? All right. So March 15th, 10 a.m. in person, March 18th for your jury trial, Mr. Lord Damon. Okay?
I'm back.
All right. All right. Have a great day. Okay?
They do it, Dembella.
Thank you, sir. Bye, Mr. Williams. Have a good day.
I just watch the judge now. She waited till he left so she could mute her mic and kind of make fun of him. All right. She went on for a few seconds, so that's funny. Heineken, thank you so much for the gifted subs and welcome all of the new members. Just a quick heads up, I am going to start putting out member-only content again. It's bouncing the idea around just Members Monday and just throwing a premiere out, every Monday. Not going to take away from what I already do, but, just some extra footage for the viewers, the members. All right. Now we're headed to Judge Boyd, where this is really interesting. Very interesting. All right. Again, thank you, Heineken. Let's go.
All right. I'll see you all for jury trial tomorrow at 9:30.
You had said if we had any pre-trial motions to bring those up.
Yes.
All right, Judge. So I had filed a motion back in August of 2023, a motion to prohibit the YouTube broadcast of all the legal proceedings.
And I don't have that motion. It's not in the court's file. We're going on the record in 2022 CR 5802, State of Texas versus Philip Diller. We're going to have parties announced for the record for the state.
Anna Ochoa Nelson.
Defense.
Alex Scharf for Mr. Diller.
All right, defense, your first motion.
Yes, Judge. The first motion is the motion to prohibit the YouTube broadcast of all legal proceedings in Mr. Diller's case. The basis for that is that he's got a constitutional right to a fair trial. And by broadcasting what happens during the trial sets up great room for error to happen. As you're aware, the court previously had a trial where one of the witnesses, the complainant, admitted to watching the YouTube testimony of at least another witness.
And you do realize that that complainant testified first, correct?
Yes, Judge.
Okay.
But just for example, that was a main witness and she admitted to watching YouTube. I'm concerned about witnesses watching YouTube. I'm concerned with potential jurors watching YouTube or asking friends or family to watch it for them. And so I'm just really concerned that Mr. Diller won't get a fair trial with this being broadcast all over the internet.
All
right, real quick. Yeah. Okay. I don't really want to deep dive into it, but just knowing a little bit more facts. I don't do the internet drama stuff, so I don't want to put a target on my back, even though I'm not afraid of them, but I just don't want that. Don't like trolls. Don't want them coming here just to, do their thing and then, try to get a reaction. I just don't like that. What was I going to say? Oh yeah, Fred. Thank you so much for the 10 memberships. Very much appreciated. Also, Jay Carr. Thank you for becoming a member. Both of you. Thank you so much. Fred, that was amazing. All right. Now let's go.
And would you want excused as well?
Usually the media doesn't video record.
Yes, they do.
Out of, when the jury's out of the courtroom. Like, for instance, like if there's a motion in limine and we're arguing about prior criminal record or something, the court grants it. I don't think the news cares about that. But if a juror were to see that, or a witness or one of the witness's friends, then they could let that slip out when the court has already ruled on that issue.
So you're okay with the media coming in filming, is that correct?
I don't have an objection to that.
Okay.
I don't have an objection to that. It's just broadcasting everything that happens in the case. The reasons that, and I will, in the motion on page 2, paragraph 5, I want to waive that paragraph because I do believe the court has changed the YouTube channel and does not allow chatting any further. And so I will waive that. I'm also concerned that there's an alleged victim who is a minor, and under the Texas Constitution, Article 1, Section 30A1, that person has a right to privacy, and that by broadcasting it, her name will be revealed. And also, whenever the jury is picked, their names are called out loud, and that's supposed to be done secretly.
All right. Is there anything else with regards to your motion, counsel?
Well, the main focus is the concern for Mr. Dillard getting a fair trial based on only the evidence that is presented in court and not broadcast or archived videos of earlier proceedings that potential jurors and potential witnesses.
Okay.
And that's just too huge a risk.
All right. And this is your only pretrial motion?
No.
All right. So that motion is denied. What's your next motion?
Boom. Is that your only motion? No, I got another one. All right, well, that's denied. Next. Keep it moving.
I haven't filed it yet. It's ready to be filed. I can hand file it. Before I file it, I would respectfully ask the court to recuse
Okay.
in this case.
Sure. We'll have a hearing on that.
Okay.
And that will be heard by Judge Hall. Ms. Ferguson, if you could call Judge Hall to see if he can have that heard immediately. All right.
Okay. And then the motion was a motion to recuse
Okay.
on that.
Oh,
So
that's fine. Oh, counsel, you can file whatever motion you want to file.
Okay.
All right, and see if he can have that heard and let him know that this is scheduled for jury trial tomorrow. So perhaps if he can hear it in the morning, and that way we can move directly into jury trial. Is there any other motion?
not for today, Judge. Like, we'll probably have a motion in limine whenever.
All right, you may want that heard because technically you have not filed the motion to recuse yet.
Right, you are right.
So,
You are right. Well, I can file it electronically when I get back to the office, or I can hand file it.
well, either you need to file it now. If you don't file it now, then we will hear other motions.
All right. Original 3 copies.
All right, and Ms. Ferguson, see if Judge Harl is available to hear that today, and we will be coming back here on the 17th for trial.
Oh, wait, today or tomorrow morning?
Let's see if we can hear it today or either early tomorrow morning.
Okay.
All right. Thank you.
Thank you, Judge.
You're welcome. Raymond Alejandro.
All right, moving on to the last clip of the evening. This is a little bit longer one. At least I think this is the last clip. I made this at like noon, so, and I was skimming. It doesn't matter. It doesn't matter. Let's just go. We are headed to Judge Bryant. I know some of you have seen this already, but it's a good one. If you haven't seen it, you're going to like it.
I believe I gave you instructions about remaining stationary, but I may not have. So I need you to be stationary. I need you to be seated in an upright position and ready to attend court. I cannot walk around on your camera. You're standing at the podium right now. We're standing at the podium. Yeah, I'm frustrated too. Can you put your head up, take your hands off your eyes, and let's pretend that we're in court. If we can't pretend that we're in court physically, then we shall be in court physically. So we either have to pretend that we're there and act as if we're there, or we shall be there. We shall actually be there in person, standing at that podium. This is case number 224557001. The people of the state of Michigan versus Sierra Renee Urell. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
For the record, Your Honor, Joseph Pernicano, P84918, appearing on behalf of Sierra Urell.
Ms. Urell, please unmute and state your name.
Sierra Urell.
What's your middle name, please?
All right, it's already starting off good. Debbie, I am sorry the volume's low. It's maxed on my end. I might have turned the volume down when I grabbed the clip. I don't know. That's always possible. But yeah, I'm sorry about that. All right, this does get a lot better. This does get a lot better.
Her name.
Especially if you're good at reading lips.
Do we need an adjournment, counsel? Or I don't know, it seems like your client is quite frustrated for some reason unknown to me. We just called the case, like we literally only called the case.
Sierra Renee Urell.
I was talking to counsel. Counsel,
Yes,
did we
Judge.
need adjournment? Did you need to talk to your client? I'm not real sure. How are you proceeding today? Because I'm not going to proceed like with hostility. That's how stuff go left, and then stuff goes left. Sometimes it's just better to be in person, because then people they, I don't know, they act a little better, maybe they act a little less hostile. I don't know, counsel, but how are we proceeding today? Because
Is it possible for me to have a breakout room with Ms. Urell? If not, then we would ask for an adjournment for an in-person hearing.
you can have a breakout with her. Did you know you can have a breakout with your client for sure, and then
Okay.
that'll also give Mr. Haddad an opportunity now to talk to the prosecutor, because he wants. This is case number 224557001. The people of the state of Michigan versus Sierra Renee Urell. Oh, this is a recall because I called it before. Okay. Counsel, you've had an opportunity to speak with your client. How do you wish to proceed?
Yes, Judge. At this time, would you entertain a motion to withdraw?
I guess so.
Judge, there has been
Go ahead.
May I proceed? Thank you. There has been a breakdown in the attorney-client relationship. We have fundamental differences regarding our understanding of the facts in this case, as well as the application of the law to the facts. Based on that, I would motion to withdraw at this time, again, as there has been a breakdown in the attorney-client relationship.
And Ms. Urell, do you agree with that assessment by your counsel?
I guess.
Okay, I guess. And then counsel, you were retained, correct?
No, Judge, I am appointed on this matter.
Oh, okay. You're appointed.
Yes, Judge.
So does that mean that, let me get Ms. Stevenson. Hold on. Give me 1 second.
Hi again. I agree with you to a point. I do think she goes overboard a lot. I don't really watch her too much anymore either. But she just sometimes has rude people. I think she held back really good in this video. I really do.
So I had an opportunity. I was trying to figure out, after you said you were appointed counsel, I was trying to figure out why you would have been appointed, because we have, defender's office. And so that's why I went in to speak with Ms. Stevenson. And then she brought it back to my remembrance. So I'm getting ready to say this to Ms. Urell. You're going to find yourself in a situation where you're going to be representing yourself, because Mr. Pernicano is the second lawyer that I've had appointed to you. Miss Urell, I need you to look at me, because you're looking up in the ceiling. So this Mr. Pernicano is the second lawyer that I've had appointed to you. And the only way that we do apple picking when it comes to picking lawyers is when we hire our own lawyers. So when you hire your own lawyer, then you get to decide what lawyer you want. You get your lawyer of your choosing. And then I was reminded that your mouth was foul when it came to your lawyer. And people don't have to put up with people being disrespectful and rude and whatever. Again, you're looking up in the ceiling. And I'm trying to be patient this morning. People don't have to put up with being cursed at when they're trying to represent you. People don't. And I think you just cursed at me because I'm good at reading.
No, I did not. You're just trying to start something. I did not just curse at you.
You said I'm trying to start something, girl. Who you talking to?
Look at you. You're being rude right now. I'm not even being rude to you. You've been rude all morning. I haven't even been rude to you.
My level best. I've tried my level best. And then she just had the nerve to say I've been rude all morning. She just said I've been rude all morning. I mean, that is so hilariously funny. I can't even put that to words. So what I'm going to do is this. We're going to all just come on in downtown. And then I won't even have to read lips. I won't have to. I mean, I've literally not, she said I've been rude. Literally not said anything about the fact
I
that
just tell you what you said.
I've literally not said anything about the fact that Miss Urell is like literally in the bed. I've not even addressed the fact that she's in the bed, and she said I've been rude all morning. And then thankfully, I don't care if you're sitting up. It is inappropriate to come to court sitting up, laying down, sitting over the bed. I don't care if you're sitting up. I know you're sitting up. I can clearly see with my eyes that you are sitting up, because contrary to popular, to your belief, because not popular belief, I'm very intelligent. I can see that you're sitting up in the bed. What I also know is that you have been rude and you cannot maintain a lawyer. I'm not inclined. So here's the situation we find ourselves in right now as you keep on talking, right? And the only reason that we can't hear you and it's not a disruption currently to the record is because you were on mute. And in this moment, the court is not going to allow you to unmute yourself. So here's the situation. I don't have to keep giving you a lawyer. You're confused in your thinking. I have given you 2 lawyers free. I've given them to you. I've provided them as according to what the law requires. And this is the second lawyer that the court has provided for you that wants to withdraw. It's the second lawyer. So here's the situation. I'm going to allow counsel to withdraw. And then Miss Urell is going to have to try to get her some more counsel. Miss Urell is going to have to get her own counsel. Or Miss Urell is going to have to represent herself. I will talk to the Michigan Indigent Defense Counsel office and see if they're willing to appoint one more lawyer for Miss Urell. And I believe the answer may be no, because what we're not going to do is keep appointing lawyers for Miss Urell to curse out or be rude to or decide that she knows best on how to do the case. That sounds like Miss Urell needs to represent herself because she believes that she knows best how to do that. So we're going to come in person. Mr. Flanagan, we'll talk about it after the docket, but Ms. Urell needs to try to see if she can hire her own lawyer. If the MIDC appoints another lawyer to this case, and let me just let the record reflect. I know it can only be reflected in the video as opposed to in the verbal record because Ms. Urell is on mute. She is slamming her hands together. She is continuously talking while the court is talking. She is slamming her hands together. She now has her hands on her head, and it's just inappropriate. So we're going to come in person in 2 weeks, and we're going to see if we can get another lawyer to do the case. And if not, that's fine too. Ms. Urell, today is January 17th. We're going to come January 31st in person. So we're going to set this in person at 9:02 Counsel. You are
All right, everybody. There's only a couple minutes left of this. I actually don't remember what her original charge was. I think they said it at the beginning. I really don't remember. But yeah, what do you think? Do you think Judge Bryant went a little overboard? Or do you think this defendant deserved it? Let me know. Let me know in the comments or in the side chat. But I'm going to peace out. Like I said, there's only about 5 minutes left. So I am going to leave, play the rest of it out. For everyone who donated members and super chatted, thank you so much. I very much appreciate it. And welcome to all the new members who were gifted memberships. All right. I will be in Discord for a few minutes after this if you guys want to hang out. But if you haven't done your jump kick backflips, please do so. It helps me out. All right. That means like and subscribe. All right. Now I'm out. Till next time. Bye.
Let the record reflect that Ms. Urell does have her hand up, and I am going to allow for her to unmute, but I'm going to state in advance and for the record that if you are rude, if you are yelling, if you are anything other than, and then let the record reflect that she is also sent directly to me, which is inappropriate, right? She has sent a chat saying, so I'm trying to figure out, you just not go let me say none, N-U-N. So that's what's in the chat. So let me just indicate for the record that is inappropriate to say to the judge. That it's disrespectful. And if that's how you're going to talk to me, when I unmute you, I'm going to immediately mute you back. And then it appears that we might need to submit the matter for a competency evaluation, but I'm going to allow you to unmute, and you're going to be respectful to me, or I'm going to mute you back. And there's nothing funny going on in my courtroom. There's nothing funny. So again, if we're not going to be respectful, then we're gonna go back on mute. Okay, so you can unmute yourself, Miss Urell.
I could talk now.
Miss Urell, what do you want to
I
say
just
to the
asked, could
court?
I speak, and you just looked around and didn't say anything.
Miss Urell, what do you want to say to the court? This is my last time asking you.
Okay, what I want to say to the court is, how y'all just go off of what some lawyer saying? You ain't asked me not one question. You ain't asked me nothing. You ain't asked me nothing.
First of all, lower your voice because you're yelling at me.
Because you sitting here trying to make it just off of what a lawyer said.
First of
I
all,
was
you're
never
yelling at me,
disrespecting him.
and I'm not going to allow that. Second of all, I specifically said, so let's rewind.
No, I know exactly what you said.
Because your memory is not, your memory is failing you, and let the record reflect that I've muted Ms. Urell. So when counsel asked to withdraw, I specifically said, Ms. Urell, do you agree with that assessment? So you said, I didn't ask you nothing. You said, I'm just going by what some lawyer said. And when counsel asked to withdraw, I specifically said, Ms. Urell, do you agree with that assessment? And then Ms. Urell said, I guess so. That's what Ms. Urell said. So let the record be clear that I, in fact, asked Ms. Urell if she agreed with the assessment. So I'm going to go ahead and set the matter for January the 31st for a final pretrial conference. It is in person at 9:02. We are going to contact the Michigan Indigent Defense Counsel to see if they will appoint a third lawyer for Ms. Urell. This will be the third and final lawyer appointed. If this relationship does not work out for Ms. Urell, then we are going to, let me disable the chat because Ms. Urell continues to speak to me in the chat, which is inappropriate. So I'm going to disable the chat. And then we are going to, Ms. Urell, if you would stop yelling, if you would pay attention, then I would take you off mute. But like literally right now, you're yelling, literally. And the only reason that we can't hear is because you're off mute. Now, what I'm going to do, let me just read for the record what she sent to me directly in the chat, which was inappropriate. Can you let me know if you're going to let the record reflect that she's clearly, like, she's, even in this moment when I'm trying to read what she wrote in the chat, she's literally yelling. But the only reason we can't hear her is because she's on mute. So she chatted me, and Madam Prosecutor, and her chat says, can you let me know if you're going to lock me up? No, okay. No, KNOW. So I can get my babysitter in order. Now, what's interesting to me is that I've not said anything about locking anybody up. We're coming in like I'm literally trying to get Miss well, let me say this to you. So you can unmute, because what's going to happen is if you keep cursing at me, what's going to happen is you are going to get locked up. Now, it's
that's
not
your
even,
goal anyways. That's your game plan anyways.
You don't know what my game plan is. You don't know anything about me. You don't know anything about me. So we're going to come in person January 31st at 9:02. We're going to contact the Michigan Indigent Defense Counsel, and we're also going to order a competency evaluation. So this is third lawyer. January 31st at 9:02 in person. Mr. Pernicano, you are discharged from the case. Everyone have a great day. Stay safe, and we'll see
Thank you.
people on the 31st.
Thank you, Judge. Have a good day.
You as well.